Start. The learned counsel for the appellants has strenuously argued that the tribunal has proceeded rather in an unnecessary haste and rejected the claim application without extending reasonable opportunity to the appellants and without considering that the claim application was being maintained by the guardian and next friend of the claimants appellants, who were suffering from physical as also legal disability, full stop. It is submitted that the claim application deserves to be examined on merits while extending reasonable opportunity of evidence to the claimant's appellants, full stop. The learned counsel appearing for the respondent insurer has duly supported the award impugned with the submissions that the claimant's appellants, having failed to establish the basic facts, the tribunal has not committed any error in rejecting the claim application, full stop. Having given thoughtful consideration to the entire matter, we are clearly of the view that on the facts and in the circumstances of this case, the impugned award cannot be sustained and the matter deserves to be remanded to the tribunal for consideration afresh, full stop. A perusal of the record makes out that the tribunal has obviously proceeded with an extra haste in the matter, full stop. The affidavit in evidence was filed on 16/4/2013 and on the next date the evidence was closed for nobody having appeared for the claimant's appellants, full stop. Thereafter, the matter was heard on 9/5/2013 and was decided on 24/5/2013, full stop. In the process, the tribunal omitted to consider that it were a matter of claim for compensation because of the death of the victim of a vehicular accident, and the claimants were said to be the persons suffering from physical as also legal disabilities, inasmuch as the claimant number 1 was said to be the blind mother of the victim, whereas the claimant numbers 2 and 3 were said to be the senior sons of the victim. Although affidavit in evidence was indeed filed by the guardian / next friend of the claimants on 16/4/2013, and hence he cannot be considered totally negligent in prosecuting the matter, but if at all the tribunal found him wanting in attending on his duties and in prosecuting the matter, alternative arrangements could have been always ordered, rather ought to have been ordered, by the tribunal for protection of the rights of the claimants who are shown to be the persons with disabilities, full stop. It appears that in its haste for disposal, the tribunal altogether failed to consider that the matter related to the claimants who were shown to be the persons under disabilities, including minors, and if at all their next friend was found not doing his duties for prosecution of the matter, the next friend could have been removed and guardian ad litem could have been appointed for the claimants on the principles referable to order 32 of the Code of Civil Procedure, full stop. The manner of disposal of the present claim application by the tribunal, without regard to all the facts and circumstances, has only requested in failure of justice, and this manner of disposal cannot be endorsed. Full stop. The Honorable Apex Court in the case of Kalyan Singh Chauhan versus CP Joshi 2011 (11) SCC 786 has explained the object of framing issues, full stop. According to Honorable Apex Court, the object of framing issues is to ascertain the area of dispute and requires to be determined by the court, full stop. Keeping in view the above mentioned provisions and object underlying them, we find that the non-contesting respondent has specifically stated that the accident had not occurred in the manner stated in the claim petition full stop, but it had occurred in order to save a child who came suddenly in front of the said bus full stop. Further, in the written statement filed on behalf of the respondent number 1, not only the manner in which the alleged accident took place was disputed, but also it has been specifically pleaded that claimants had no cause of action to file the claim petition and claims tribunal had no jurisdiction to try the same full stop. The Honorable Apex Court has held that in the matter of adducing evidence, parties are not guided by the pleadings but by the issues full stop. In the present case, non-framing of material issues have resulted in non-production of material evidence on those points full stop. In this case, the Honorable Apex Court has further observed that the court should not decide a suit on the matter on which no issue has been framed full stop. This legal proposition is enough for us to come to the conclusion that the learned tribunal has rejected the claim petition on the ground in relation to which no issue was framed by it full stop. We are further of the opinion that non-framing of issues have resulted in non-production of relevant evidence. Therefore, the claim petition was not fairly tried full stop over.